medium-sized business owner, do I really need a lawyer if I'm not being sued? Welcome to part one of a three-part series responding to this question. Today, I'm going to discuss various reasons why you, as an entrepreneur or business owner, should consider engaging legal counsel even if you're not being sued. If you are being sued, or you're about to be sued, or you need to sue somebody else, please speak to an experienced litigator sooner rather than later. Later in this series, I'll discuss items that you can probably handle yourself with or without some initial or ongoing support from an attorney. The recurring theme throughout this three-part series is that a good lawyer is going to help you create a strong foundation that will allow you to manage most day-to-day business operational needs independently without having to consult your lawyer multiple times per day or even every month. A lot of times, this will look like incurring the short-term costs up front to build this legal foundation in order to enjoy longer-term cost savings and risk mitigation. So without further ado, here are some common reasons why you may want to consider engaging a lawyer as a small or medium-sized business owner. First, commercial contracting. Commercial contracting is also going to be at the top of my list of items that you can handle by yourself, so let me explain. Unless you have salaried in-house counsel and it falls within the scope of their responsibilities, you probably do not need a lawyer to go through every single contract you enter into with a fine-tooth comb. But you should consider engaging someone with experience in commercial contracting to review and negotiate any major contracts on your behalf. Major in this context can mean major dollar value, major importance to your business, major risk, or otherwise. If your vendor, supplier, client, or whomever insists that you use their standard contract, it's likely that it's drafted in a way that's very favorable to them. Sometimes it's favorable in a commercially reasonable way, and sometimes it's so absurdly one-sided that it borders on unconscionable. And especially when the other contracting party has more bargaining power, you might be inclined to just agree to their terms as is, without understanding what you're getting into, and then expecting that you can trust them because their sales team insisted that the agreement was reasonable and fair. Sadly, I've had clients whose businesses get strung up over a single nasty agreement with a stubborn other party that insists on strict compliance when the relationship sours. If there's a potentially significant impact on your business, it's better to have a lawyer review it before you sign it, so at the very least you'll have an accurate understanding of what you're agreeing to, and you can make a calculated risk if the provisions aren't negotiable. And if your business will have you entering into many agreements with lots of different clients or vendors, there's an opportunity for your attorney to actually create your own standard forms so that your preferred terms become the default, and then it will be up to the other party to negotiate them down. Next, intellectual property. As I'll discuss in the third video, there are some basic IP-related matters where you can save your legal dollars and either complete registrations like copyright and trademark by yourself, or just chance it and rely on the common law rights that will adhere. But for other matters, having a lawyer involved is critical. If you're licensing your intellectual property, for example, you want to make sure that you aren't licensing out greater rights than you intend. You need to create rules around derivative works, and you should set forth what happens upon expiration or termination of the license for cause. In a work-for-hire contract, you need to clearly define the scope of the work product you're purchasing, negotiate moral rights and display rights with the author, assign liability for infringements of any third-party IP, and so on. And if you've invented something, you really need a specialized patent attorney to navigate the process. Intellectual property is an area of law where I've seen the just reuse a contract from the internet approach go truly, disastrously, appallingly wrong in a way that neither party realized until it was too late. For employment matters, you'll see that the recurring theme today is all about creating the right foundation and bringing in your lawyer when things are especially complex or go wrong. If you're hiring anyone, either as a W-2 employee or a 1099 independent contractor, I'd really encourage you to consider speaking with an employment lawyer first. Having the right agreements in place can help prevent costly reclassifications. Make sure you have grounds to terminate an underperforming or unacceptable employee as quickly as possible within the bounds of state and federal law. Avoid disputes as to salary, benefits, vacation, or other entitlements, and so much more. And getting a lawyer to help you develop appropriate corporate policies, termination procedures, an employee handbook, and employee training as needed can greatly reduce your risk of lawsuits from former employees and can even operate as a defense in some cases. Highly regulated industries. If you operate in a highly regulated industry, whether at the state or federal level, or both, you'll want to engage a lawyer to ensure that your business operates in compliance with all applicable rules. Obviously, businesses in healthcare, finance, pharmaceuticals, transportation, and agriculture are heavily impacted by regulations. But so are restaurants, pawnbrokers, gambling and gaming enterprises, companies engaging in international data transfers, waste management companies, and insurance brokers and advisors. Depending on your needs and your internal compliance and risk management staff, your lawyer doesn't necessarily need to be an expert exclusively in your industry, but some relevant knowledge and experience helps even when they aren't being engaged solely for regulatory compliance purposes. Corporate transactions. If you are buying or selling shares or membership interests in a company, or you're buying substantially all of a company's assets, or you're taking on a new owner or investor, or you're buying out your current business partner, or you're merging with another company, the list goes on and on. You really do need an attorney involved, ideally before a term sheet is drafted or a letter of intent is signed. Not every transaction needs 6 months of due diligence and a 70-page purchase agreement. And different attorneys in different firms focus on transactions of varying sizes and complexities. So just as a tiny law firm that generally handles transactions under $5 million is not going to represent a Fortune 500 company that's acquiring its competitor, you don't need an AmLaw 100 firm charging $900 an hour for a second-year associate who's essentially still a trainee to manage the sale of your $850,000 business. And those firms generally aren't going to take you on as a client anyway. But you do need a lawyer, and you can find somebody professional and experienced in smaller size transactions, probably for half of what you pay for a junior or mid-level associate at a larger firm. Real estate matters. If you're signing a commercial lease for your business's brick and mortar location, you may or may not want to have an attorney review before you sign, depending on how much time you have and your comfort level with reading through, understanding, and potentially negotiating a lengthy legal document and any personal guarantees. But if you're renting out all or a portion of property that you own to a tenant, or you're subleasing under an existing rental agreement, or you're buying, selling, or developing property or dealing with zoning issues, I'd strongly urge you to get legal representation. For rental agreements and other commercial leasing issues, most strong corporate generalists can do a solid job, but I'd encourage you to find a true real estate professional for any purchases or sales of real property. You need a lawyer, but specifically, you need a competent lawyer and a subject matter expert. And there are some sleazy corporate generalists and M&A guys who will claim that they can handle real estate matters, and then they botch it to their clients' irreparable peril. This is true across all legal subject matter, of course, but the most disastrous situations I've seen have been where underqualified lawyers do real estate and IP work. They screw it up due to their inexperience and incompetence, and it costs their clients hundreds of thousands, if not millions of dollars. Okay, this was just part one. In parts 2 and 3, I'll address the flip side of this question. That is, when do you not need a lawyer, or at least not necessarily? Business owners. What was the reason you first hired a business lawyer, and how have your needs changed or expanded over time?